Our next speaker is going to address international patenting and technology licensing issues. The speaker is Mr. Greg Ludlow. And let me just find his curriculum vitae and I'll read it. Gregory Ludlow is a partner in the intellectual property law firm of Macbeth & Johnson, which is associated with the patent and trademark agency firm of Dennison Associates. He received his Bachelor of Laws degree in 1979 from Osgoode Hall Law School and was called to the bar in the province of Ontario in 1982. Mr. Ludlow has practiced exclusively in the field of intellectual property law, both as a barrister litigating patent, trademark, copyright, and trade secret cases, and as a solicitor advising and negotiating in respect of transfers of technology and licensing. He is the author of Recent Developments in Canadian Law Intellectual Property, to be published in the Ottawa Law Review, Part 1. Summary of Government Activity is scheduled for publication in Volume 25, Number 1, in late October, early November 1993. Mr. Ludlow is chairman of something that's called TRIPS, which is Trade-Related Intellectual Property Subjects, Policy Committee of the Patent and Trademark Institute of Canada, and a member of the Canadian Bar Association since 1976. Would you please join me in welcoming Greg Ludlow?
Thanks very much, Stephen, and good morning, everyone. The topic I've been asked to address by Stephen is the question of getting protection for intellectual property and then essentially exploiting that intellectual property from a global perspective. That's a difficult task to do in the span of any paper and the span of a short presentation. What I've tried to do is highlight for you in two parts the basic considerations to keep in mind when you're looking at patenting beyond Canada, and then as a separate part, some of the international concerns that are raised when you're looking at international licensing. I'm not going to provide you with a comprehensive guide to international, or rather technology licensing. There's an excellent guide that's been prepared by the federal government entitled Supplying or Acquiring Technology, a Canadian Business Guide. It's a comprehensive 118-page guide that I commend to all of you from the perspective of understanding the concepts, practices related to technology transfer and licensing. It came out in 1986. It's been updated in 1991. And I think if you take a look at that, you'll get a very good idea of the kind of concerns that you want to address when you're looking at technology transfer or licensing. Leaving that recommendation then and considering the discussion today, the first part will deal with patenting and a subheading that I've added to it, foreign matters. I'll look at initial considerations, including general principles to keep in mind, as well as the focus that you should have when you're considering patenting. I've approached this presentation in the paper today from the perspective of your being generalists. Those of you who've got experience in the field may find the presentation in the paper dwells on some of the basics and fundamentals, but from the perspective of presenting the topic to a generalist, I've focused my talk with that context in mind. The other point that I'll address in the part dealing with patenting and foreign matters are the patenting approaches that you should keep in mind, including convention priority, the U.S., European patents, and the patent Cooperation Treaty. The second part will deal with the international concerns that are generated when you're looking at technology licensing, and there's an international dimension to it. Now, turning to the first part on initial considerations, to begin, generally, it's important to recognize that patents are characterized as a bargain between society and inventors to encourage progress. The inventors disclose their new ideas for functional apparatus, processes, products in exchange for an exclusive right to exclude others from making or selling or using that idea. There's a qualification for the inventions to be novel and ingenious. The concept of novelty is one that you have to keep in mind. And in fact, when you're looking at patenting, probably the key consideration to keep in mind when you're approaching patenting is the notion of disclosure. The consequences of disclosure are twofold. You may end up spoiling the opportunity to pursue the exploitation of the technology as a trade secret if patenting turns out to be unavailable. And you may trigger a clock, you will trigger a statutory clock that may raise bars to the patenting of the technology. So that's a fundamental concern. To be ingenious, the invention has to be something more than a workshop improvement, something that a person skilled in the art, a workshop improvement being something that a skilled person in the art would come to without the use of any inventive ingenuity. That's a vague concept expressed in those terms, but there's a body of jurisprudence, a gloss that's been put on that term that you can have reference to. The term has been added to Canadian law. It's a requirement in terms of European law and most major developed patent systems. When you look at patent protection, you have to keep in mind that, with rare exception, patents are only effective in the territory of the sovereign that grants the patent. And so you're really looking at the question of how do you gain patent protection in multiple jurisdictions. Another consideration to keep in mind is that there are two regimes for patent protection. One, the more common examination regime, the other being the registration regime. The examination regime is the more common. The chief virtues of that examination approach are, the examination procedure gives the patent a degree of certainty in terms of its validity. If you have a simple registration scheme, the patent is granted, and the question of its validity is contested by the citizens without any extra certainty being provided by the sovereign granting the patent. With respect to the examination system, there's a scrutiny that's provided. There's a search and a retrieval of prior art. The patent is assessed against that prior art and other criteria, as I've mentioned, novelty, ingenuity. Patents have to be in respect of useful subject matter, and there are certain restrictions in terms of the subject matter that apply that can be patented. The benefit of that extra certainty is that it gives the technology that extra certainty in terms of validity, which will attract investment capital. When people are looking at investing in technology, they want to know initially whether it can be patented, and if it is patented, what's the strength of that patent. The examination system, where it's rigorous, gives the person interested in the patent, be it the applicant or the person interested in taking the license, a valuable sense of certainty. It also provides, and this is a point that goes back to the question of disclosure. The examination system allows the applicant to make an informed election as to whether he wants to pursue a patent or whether he wants to exploit the technology by keeping it secret. When you file a patent application, the application itself is kept secret in most jurisdictions for a certain period of time. If you're able to get an examination search done and you make an assessment as to whether or not the technology has a decent chance of being patented or not, and particularly in circumstances where prior art is uncovered that has not come to light before, the applicant is able to make a decision then as to whether he wants to continue the pursuit of the patent and the eventual publication and disclosure of that technology, or whether he wants to keep it confidential. And so one of the things that examination does is it provides that knowledge at a stage early enough if the proper steps are taken to enable the applicant to make that determination. It's a consideration that's often overlooked. The value of patents and the exclusive monopoly that goes with patents is very attractive and adds a good deal of value to the technology. But in getting to that stage, don't overlook the question of disclosure and the repercussions of disclosure when you're considering whether to patent. And generally, you can look at the patent systems in the world and make a fair assessment as to the strength of the patents that will issue from the various jurisdictions based upon the sophistication and the vigor of their industrial economy. The more vigorous the economy, generally the more rigorous the patent examination that is applied. Germany, the Netherlands, Japan, the United States are all recognized as having particularly strong, rigorous examination systems. The point about disclosure is worth commenting on by way of illustration to give you a sense of its importance again. In a number of jurisdictions you can file, and in order to alleviate the administration of that system, a number of companies have elected to have what's called a deferred examination system. Unless the applicant requests examination, the examination won't take place. And so if you're not mindful of that fact, and you simply have the application filed, the application can be laid open for inspection or published before there's any scrutiny as to its worth in terms of prior art examination. Be mindful of that fact and encourage the applicants to request examination simultaneously with filing. And the repercussion of that, of course, is that if there's disclosure through publication or the laying open of the application, the applicant has no opportunity to preserve the exploitation of the technology by way of a trade secret. To further complicate matters for your consideration, in general terms, there is the fact that there are two systems of entitlement for patents, first to file and first to invent. The United States, the major market, is a first to invent. So are the Philippines, and most everyone else in terms of examination systems is first to file. Now, the crucial thing in patenting is to know your client's objective. Think globally when you begin this exercise. Traditionally, Canadian inventors have looked at Canada and the U.S. Now they're looking at the world. As I've mentioned, consider whether you even want to patent. There are times where exploitation as a confidential trade secret, if the subject matter is appropriate, is perhaps the best way of exploiting the technology, given the imperatives of the marketplace that encourage people to imitate. It may be best to keep the matter secret and exploit it in that fashion. Factors that you should consider, I've set out there, are the nature of the technology, whether it's appropriate subject matter, what are the potential markets. There may be some geographic specific concerns. It's not likely that Australia is going to be interested in some cold weather technology. In terms of revenue potential, think about obviously the markets that have the potential for successful exploitation of the technology: Canada, the United States, Europe, Japan, Australia, Mexico, the emerging Southeast Asian economies. Look at the question from the perspective of what your client wants to do with the technology. Do they want to exploit the technology themselves directly? Do they want to simply license it? Do they want to engage in a hybrid of that activity? In some territories, exploiting it themselves; in other territories, having somebody license it; in other territories, engaging in a joint venture. Look at the question of resources. Can they afford to patent everywhere that they want? Can they afford the necessary effort to successfully exploit it everywhere they want? And look at time constraints. Are there any market opportunities that might be lost if a patent is not sought, and the added value of patent protection not given to the technology? Look at it from the point of view, as I've mentioned before, of the severe consequences of the statutory bars against patent protection. In terms of the patenting approaches, as I mentioned, there are four basic approaches. The one is convention priority, and we're looking at filings in multiple jurisdictions. The other is the national approach. The other is the regional approach. And then finally there's the very beneficial patent cooperation treaty. The convention priority is under the Paris Convention that's been established for decades. Canada signed on in 1934 to the London text and is encouraged now as a result of NAFTA and to sign on to the most recent text. The benefit of the convention priority is twofold: national treatment, so that residents of member states are accorded the same treatment in terms of patent protection as nationals of the country in which the patent is being sought, and the most important benefit being convention priority, which is in terms of patents a year's grace, which, when you're looking at the investment in preparing, prosecuting patent applications, is extremely valuable. You're given an opportunity, if you file in a member country, to file anywhere else within a year and be insulated against any intervening acts of disclosure or publication or filing that would otherwise bar your application in those further countries. Another important point about this is in the context of the United States, which I'll turn to shortly, and that is the United States has a system of first to invent. Beyond that, it's really first to invent in the United States. And so if you have a convention filing, that can be used to establish priority of invention in the United States. So take advantage of it. I've looked at the United States because of the tremendous appeal that it has. Normally in a national approach, you take advantage of a convention priority and then look at the individual jurisdictions that are of interest and file in that country. The United States is the major market, and it has been traditionally a place where inventors go to seek the patent protection and enjoy the exploitation of technology in that market. It's a first to invent system. I've mentioned that the inventive activity is in the United States. NAFTA obliges the United States to look at inventive activity in Mexico and Canada. Whether or not those changes will be clearly enshrined in the U.S. patent law remains to be seen. There's a comment by a generous U.S. practitioner in the Patent and Trademark Institute of Canada Bulletin number 10, October 1993, in which he describes the current efforts to change the U.S. patent law. And his suggestion is quite clearly that there's an effort to leave it ambiguous. The other main point to consider with respect to the U.S. law is the duty of disclosure to the Patent Office. You have to bring to their attention any material facts that would affect the examination of a patent. With respect to the European system, it's a rare exception in that a European patent with designated countries is one patent that is valid in all of those countries. It coexists with the European national patent systems. The cost savings, the rigor of examination performed by the examiners in Munich is such that when you're looking at Europe, most people are well advised to consider a European patent application. You can file your application, you can withdraw before issuance, so you can cover the community, and if it turns out you only want to exploit in some particular collection of those countries, you can amend at that time. The term is 20 years. It's a first-to-file system. There is as well an absolute novelty in the sense that it can't have been disclosed elsewhere. There's a short grace period of 6 months. Looking at the Patent Cooperation Treaty, and this is by far the most valuable approach now. It's a major initiative to encourage filing and to reduce costs. It's a two-phase procedure, the international phase and the national phase. The international phase consists of an international application that is acceptable in all member states. It's one application in one language in a single office. You get an actual filing date in all of the countries where you designate, all of the member states. That's an enormous time saving, depending upon whether you want to go into a further chapter where examination by the international agency is performed. You can extend the period of time. The benefit of the filing is you have between 20 to 30 months to decide which of those designated countries you want to pursue. That's an enormous time saving when you look at the national filing fees, the cost of translation that is associated with national filings. And so deferring the question of when you enter the national phase is extremely valuable to most applicants. Canada joined in January 1990. The trend now is to Patent Cooperation Treaty filings. Turning to the second part of my presentation, international licensing concerns. Stephen encouraged me to close my remarks at 11:20. I have 3 minutes to do that. I hope you'll be generous and give me a few more minutes. The concerns I've set out in my paper are concerns that, as I say, do not purport to be comprehensive, but are concerns that are often triggered when there's an international dimension. If I can go through those briefly with you. Consider the existence and the effectiveness of the technology rights in the local markets. It may be that there is no patent protection or even trade secret protection. It may be that ownership has to be considered. You're going to hear later this afternoon about the question of marketing in Eastern Europe. Who owns the property in Eastern Europe? Who owns the property in Russia? Well, don't let that question necessarily be an impediment to your choice to exploit technology in Eastern Europe or Russia. Consider business insurance against that risk. The effectiveness of the protection has to be considered as well. It's fine to have the protection on the books. It's fine to get the patent. If enforcement is, in practical terms, minimal or non-existent, then you're really only looking at deterrent effect. And the competitors will soon gauge the degree to which people can enforce their rights in their country. Mexico is a classic example of that, where previously the enforcement was placed on the shoulders of the government. Now that means that enforcement depends upon the government having the resources to enforce those rights. Great strides have been taken to increase the effort at enforcement in Mexico, but it's a handful of individuals that perform that task. In a country of 80 to 100 million people, with a growing economy, it's woefully inadequate. You could not pursue those matters civilly before trial. You can now, given the changes in the Mexican law. But that's a fundamental question. Not only should you look at whether the standard of protection is there, but whether enforcement is effective. In terms of general contract concerns, look at the clarity of the contract, choose a single language to govern interpretation and notices, and the wisdom of defining terms is particularly important in these types of agreements because there are no implied terms in technology and licensing agreements. Refer to published definitions of technical terminology or technical standards. In terms of the law of the agreement, you may insert a term that suggests that the law will be the laws of Ontario, but recognize that different aspects of the agreement are governed by different laws. Where the contract is made, that jurisdiction's laws govern the question of whether a binding contract has been made. When you're transferring rights such as patents, the local law of the patent will dictate whether the transfer binds others. And bear in mind that there will be laws that take effect where the subject matter involves trade in their jurisdictions. A classic example of that is the European Economic Community, where if you're involved in European trade and the agreement affects European trade, then their laws will govern. In terms of contract specifics, look at the question of whether a purchase or a license or some other method of exploiting the technology is best employed. Market restrictions. These are concerns that come up in every technology transfer licensing situation, but you may find that the particular international dimension will raise concerns that domestic licensing you won't be required to address them. In terms of market restrictions, the barrier's about to fall now, so most of the notes are set out in the paper there. In terms of the contract specifics, a fundamental concern to keep in mind is the effect of competition laws. In terms of market restrictions, in terms of price, in terms of exclusivity, in terms of territory, in terms of the transfer of the rights, those concerns have to be scrutinized with particular care because you're involved with rights that in and of themselves grant monopolies. So there's an overlap that has to be considered. Now, with respect to taxation, I'll just mention three that are important. Look at how the tax treatment will be accorded to the transaction. Look at the question of withholding tax. The subject matter may be treated differently. GST applies to technology transactions. VAT applies to technology transactions. You also have to be aware naturally of the currency concerns. You may, with technology, have to address the concern of statistical reporting requirements, and you will also have to consider the question of control of technology. Now, I've spent more time on the patenting side of it. The paper addresses the kinds of concerns that I've raised in respect of technology licensing, and welcome any questions that you might have.
Are there any questions?
Thank you very much, Greg. You could tell that you weren't addressing an audience of intellectual property lawyers, Greg. I'm sure you'd be inundated with questions about the Patent Cooperation Treaty or the Paris Convention.
Well, it's not a magical field. So.
Our next topic is, I will address, and it has to do with legal opinions in international transactions. Legal opinions at any time are difficult to settle. We, in this country, have our own problems domestically with settling the who's responsible for what in terms of bank financing transactions and what's the appropriate requirement for enforceability type of opinions and what are appropriate qualifications to opinions. We don't, particularly when you're dealing between provinces. In the international transaction, it is complicated that much more by the fact that you have two parties that are governed by two different legal regimes. But the international legal opinion is, in my view, and certainly in the any kind of contractual arrangement of any duration, is really something that you ought to ask for, because by asking for a legal opinion addressing the issues which I'll get into in my paper on the international legal opinion, you'll begin to understand what problems you may have with enforceability of the agreement, or essentially what the agreement means. The international legal opinion addresses a number of issues. One of the key issues is the validity of the governing law provision. It also will deal with the enforceability of the agreement itself in the foreign jurisdiction, and it'll deal with the effect of what I call choice of forum clauses, which are contractual submissions to jurisdiction or agreements to settle disputes in a particular jurisdiction. I call them choice of forum clauses. The opinion will also deal with corporate capacity, authorization, execution, and delivery. And these are matters. Those matters are matters of formal validity, and they are not unlike the types of opinions that we deliver domestically, except that the considerations involved can be somewhat more complicated, dealing with parties in two different jurisdictions. And we'll try and keep this fairly simple. What the international legal opinion addresses is the conflict of laws rules that impact on the transaction and the agreement that we're dealing with. So you have to begin to understand what it is that you need from foreign counsel. You have to understand yourself Ontario conflict of laws rules as they may apply to your particular agreement, and then that will put you in the game, as it were, to ask the appropriate questions of foreign counsel on such things as validity of the choice of law provision, enforcement of foreign judgments, the enforceability of the agreement itself, and the effect of forum selection clauses. The paper I presented goes through these issues in some detail, and I've tried to keep it fairly simple, and not to suggest that there's any one way of doing it, because there isn't, but there's certainly, I think it's fair to say, one methodology of approaching particular issues. The actual form of the opinion, I provided a sample form at the back of my paper, a foreign counsel opinion. You know, I think it's one that you could use in most transactions as a starting point. And if you understand the reasons why those particular clauses are in there and why you're asking for that opinion, then that'll help you to understand whether you're prepared to accept certain qualifications that may be requested by foreign counsel. I've provided in the paper an example of a Canadian supplier who supplied goods for a number of years to a foreign customer. This is intended to be a very simple example, and I'm sorry if, I apologize if people find this, very trite, but anyway, these things do happen on a regular basis. We have a Canadian supplier who supplies a foreign customer, has been doing so for a number of years. The supply is on open account terms, so there's no letters of credit. Foreign customer is in some difficulty, has extended his terms of payment. Represents a decent customer to your Canadian supplier, so the Canadian supplier who wants to continue to supply, his Canadian supplier makes money off its sales, provided it collects. And so the foreign customer has negotiated a sale of his assets to an independent third party. This is the example we've created. It's a real situation that I dealt with just recently, and so as I was doing the paper, or updating a paper that was previously delivered for the CBAO, I tried to integrate this particular problem. I always find examples helpful. So what happens is that the third party will assume that the third party is in the same jurisdiction as the foreign customer to keep things simple, and that third party is going to buy the assets. Your client, the Canadian supplier, has been asked to consent to the sale of the assets, and he will do so and wants to, he or she will do so, it will do so, wants to continue to do business with the independent third-party purchaser. But we've got to have some documentation put in place to establish that the independent third-party purchaser is going to be responsible now for the indebtedness to the Canadian supplier. He's going to assume the indebtedness when he purchases the assets. And so that will necessitate the drafting of what I've called in the paper an assumption agreement. And the assumption agreement might also deal with trade terms and the right to terminate the future supply relationship, as well as other types of legal issues relating to pricing and that sort of thing, volume discounts or promotional allowances in the foreign jurisdiction, etc. The comments that I'm going to make, of course, apply to other agreements other than just, a very simple assumption agreement. They would also apply to joint venture agreements or distribution arrangements, sales agency arrangements, the whatever commercial contract, international commercial contract you're dealing with, you will still have to deal with the conflict of laws issues that impact on the agreement, and you'll have to deal with your choice of law provision. So the paper also addresses, the paper begins by addressing, from the point of view of this assumption agreement being governed by the laws of the province of Ontario. So your Canadian supplier feels a little bit in the driver's seat and says, well, I'd like the laws of the province of Ontario to apply. But the paper goes on to also deal with the reverse situation where you're in the shoes of foreign counsel, you're advising your Ontario client with respect to a contract that has as its governing law clause the laws of a foreign jurisdiction, and you've been retained perhaps by foreign counsel to, or by counsel in a foreign jurisdiction to provide some sort of opinion as to what Ontario courts, how Ontario courts would view this agreement and the party's choice of law, etc. You'll see that on page 2 of the paper I've settled some very basic definitions to help to understand how we could address some of these issues in our discussion. And what I've done is I've said that for the purposes of our discussion we'll call the governing law clause, or the governing law, the laws of the jurisdiction which will govern the what's commonly referred to as the construction, interpretation, and essential validity of the agreement. So that'll be the governing law of the agreement. So when I speak of governing law, I mean the law that has either been expressly chosen as the law that'll apply to the contract, or in circumstances where that hasn't been expressly chosen, the law that would apply given the connecting factors surrounding the agreement that would serve to illustrate what the party's intention was in terms of which laws do actually apply to this agreement. So we'll talk about governing law as the laws governing the essential validity, construction, interpretation of the agreement. And we'll talk about principal counsel being counsel practicing in the jurisdiction of the governing law. Foreign counsel will be a counsel acting on, for the foreign party who's located in the foreign jurisdiction. I think that's fairly straightforward. Principal jurisdiction is the jurisdiction which has the governing law, and foreign jurisdiction is the other jurisdiction. So if we can have those definitions down, you would see that Canadian supplier would be the principal party, Ontario counsel would be principal counsel, because as we've said, we've chosen Ontario as the governing law. And the independent third-party purchaser would be the foreign party, and counsel in the foreign party's jurisdiction would be known as foreign counsel. This is a very common situation, and I want to just make a couple of comments about retaining foreign counsel before I get into the actual opinion. Wherever possible, I try to retain foreign counsel independently of the foreign party. Even though you may be initially contacted with or dealing with foreign parties' counsel, I find that it is much less adversarial in negotiating the type of opinion that you can obtain if you retain counsel independent of the foreign parties' counsel. In addition, your own foreign counsel, independent foreign counsel, is probably more likely to raise legal issues that might be an impediment to enforceability of the contract than would foreign parties counsel. I'm not saying, I don't want to cast aspersions in anybody's direction, but the truth of the matter is, independent counsel is acting independently and looking after your interests. So they're more likely to focus on issues that maybe are not front and center, but your client ought to be aware of. I make it my practice to only retain, to the extent possible, only retain foreign counsel who are members of the International Bar Association for no other reason than I think that's a good starting place. Somebody who's a member of the International Bar Association has indicated in some fashion that they're interested in this area. That doesn't mean because they're a member of the IBA that they are somebody that I would retain, but I start there, and then I try to get a sense in our initial conversation of whether or not the foreign counsel has some idea of conflicts of law. If they don't understand basic problems of conflicts of law and validity of law opinions, validity of choice of law opinions, then you're really not doing your client the service by trying to educate that party in the transaction. So they should have a basic understanding of conflicts of law's rules, and quite often you'll be able to find somebody who knows something about that in a firm, or if you scout around in a particular city, you'll find some people who are familiar with those areas, depending, of course, on where your transaction is occurring. The other aspect that I would mention on retaining foreign counsel is liability insurance. I'm not afraid to ask counsel who we're proposing to retain what kind of liability insurance they carry. It's a good example of different jurisdictions having different rules. In Ontario, because we have minimum $1 million insurance requirements. In the U.S., there is no mandatory, in most states, I don't know of any states that have mandatory insurance requirements, for example. You might, I don't think there's any shame in asking, for some comfort that the firm in question has liability insurance, the amount of that insurance coverage, et cetera. And if you feel that the transaction is particularly sensitive, maybe you want to take it further and have some evidence of insurance, depending on the transaction. Remember, it's your exposure, and there is some, although there's no cases specifically on this issue, there's no question that the authorities say that there's some responsibility here of a principal counsel and retaining foreign counsel to make some assessment that the foreign counsel that they're retaining is the appropriate, is able to deal with the issues, and so you act as a reasonably prudent solicitor. Now, the key issue is settling the conflict of laws rules on on the validity of the choice of law provision. I've said in pointed out in page 3 of the paper what the principal party will want to know. That's really simple, and it's a good place to start. You say, what does the principal party want to know about this agreement? Well, he's going to want to know, she's going to want to know that the agreement is a valid and enforceable agreement after it's been signed. Okay, sounds very simple, but I think they're entitled. And in fact, I'll go further and say principal counsel should be duty bound to be, if they don't actually formally deliver that opinion, are required to deliver, are required to be in a position to deliver an opinion at the end of the day. The agreement that's signed is binding and enforceable. There's another reason, however, why the conflict of laws issues are important, and that is the Canadian supplier in our example will want to know that if there's a dispute that arises, that he would or she would prefer to sue in Ontario as opposed to a foreign jurisdiction. This is your forum selection clause. A lot of people address, the validity of choice of law provision is valid, binding, and enforceable, and then forget that 3 or 4 months or 6 months from now, if there's a default, then they say to their client, well, we're going to have to, after they do their investigation, they say, we're going to have to sue in. Now, I can tell you, your client is not going to be real, even if they don't say it to you on the phone, they're going to get off the phone. Somebody's going to ask the question, well, how come we have to go there, and couldn't we have addressed this up front, and where was our counsel on this? So, you should ask the question about forum selection clause. Is it enforceable or not, okay? And then that's also important, even if it's not enforceable, we'll get into that in a few moments, on the actual enforceability of a forum selection clause. I agree that the dispute will be resolved in, you need to pick a jurisdiction, even if that's not necessarily enforceable, for reasons that I'll discuss in a few minutes. There's a secondary aspect to that question, and that is whether or not that term creates, both in Ontario courts and more importantly perhaps in the foreign jurisdictions courts, in personam jurisdiction in a conflicts of laws sense, such that if you received a judgment in Ontario, that it would be enforceable in the foreign jurisdiction and not found to be unenforceable because the party never had a place of business in Ontario and was an absent defendant. And so you're quite entitled to bring your action, but at the end of the day, you get a judgment that's not enforceable. So those issues in a very basic agreement ought to be addressed. And again, I think if they're very practical and important, and if you don't address those issues, I think that really the service that you're offering to your client is I'm afraid, is a poor one, and your client's going to be unhappy when they find out that they have to sue somewhere else or that their agreement's unenforceable, that sort of thing. There are a number of other issues which the principal party will want to address, and I'm going to ignore those for now. They've been touched on by Greg, but they will be local jurisdiction rules or foreign jurisdiction rules, such as security rules, if they want to improve their priority position. Typically that's governed by the law, the situs of the goods. As well, they may want to know something about the bankruptcy or moratorium insolvency rules of that foreign jurisdiction. And they may also want to know, with respect to terminating the relationship, which Bob Cosman's going to address after lunch, they may want to know what their obligations are if they terminate the supply arrangement or the agency arrangement, distribution arrangement. Those are what I call advice type reports or opinions, and they're not the type of opinion that I've addressed in my paper. They are important to the client and they make for great discussion and really interesting discussion, but they're not the focus of this particular paper. So what I've said is the key starting point is validity of choice of law. What you can't assume, let's say we have our agreement and it says it shall be governed by the laws of the province of Ontario, so independent third party has said he's going to pay over a period of time the amount of debt that's assumed, and yes, the contract can be governed by the laws of the province of Ontario. Independent third party is prepared to sign a document that says that. You can't assume that because Ontario law generally respects the freedom of parties to choose that choice of law, that the courts in the foreign jurisdiction accept the party's freedom to choose their choice of law. The parties, the rule with respect to the validity of choice of law in the foreign jurisdiction may be that, that regardless of what the parties agree to, the laws that are applicable to this contract are the laws of the place of last contracting, or called lex loci contractus, or the laws where the contract is going to be performed, or you may be dealing in certain Latin American countries that say, well, we're not interested in trying to apply somebody else's laws. You're in our court, we apply our laws, and the laws of the lex fori are always applied. So this is what you're getting at when you ask for an opinion on the validity of the choice of law. You're asking for an opinion that the parties having chosen the laws of the province of Ontario, that a court sitting in foreign jurisdiction would accept the party's choice of law and would apply Ontario law should an action be brought in the foreign jurisdiction. So even though the situs of the action is brought in foreign jurisdiction, you're going to prove, or you have your experts to prove what Ontario law says about the interpretation or the essential validity of this contract and what the rights and obligations of the parties are based on Ontario law, and that's the law that will be applied by the foreign jurisdiction. There is always limitations. I think it's fair to say there's always going to be limitations that are provided on a party's choice of law provision. So in other words, you may get an opinion from foreign counsel that says, well, your choice of law is fine except that, and then there'll be limitations. There's limitations in Ontario. In Ontario, the rule is parties are free to choose their law provided that their choice of law is bona fide, legal, and not contrary to public policy. Okay? So, bona fide, if you look at the case law, this is established by the Vita Foods case, which is referred to in the paper. It's been around since, I think, 1937 or something. Bona fide is not entirely clear, but probably means that as long as there is some reasonable connection with the jurisdiction whose laws you've chosen, then the choice is a bona fide choice. There's some connecting factors. Legal probably means that you haven't chosen a particular party's laws, jurisdiction's laws, in order to avoid the invalidity of the agreement if absent the choice, the proper law of the contract based on connecting factors would have been another jurisdiction which would have made the contract void. So that's what legal means. Public policy is in Ontario means important public policy. And there's a case called Boardwalk and Maloof that deals in the context of enforcement of foreign judgments. It's also quoted in the paper, some aspects of public policy. This is a case involving enforcement of gambling debts in Ontario. So you're going to find out from the other party, from foreign counsel, whether the choice of law is valid, and they're going to advise you of the limitations. And let's suppose, for example, and it's very common for foreign counsel to say, your choice of law is fine as long as it doesn't, and our courts will apply Ontario law, provided Ontario law doesn't violate any terms of any important public policy in our jurisdiction. Well, this happens all the time, and then you will say, okay, what does that mean? Because I don't know what your public policy is. And foreign counsel will say, well, that's a pretty broad question. And then you'll say, well, let's just confine the question to this agreement. Do you see anything in the agreement that might violate public policy? Hopefully counsel will say, no. Some counsel, you may find this with New York attorneys, they'll say, well, I couldn't really tell you that because I don't know enough about Ontario law and how they'd interpret your agreement to be able to tell you whether or not there's anything in the contract that wouldn't be enforceable. So so this is called the opinion gap, okay? This is an opinion gap. It's acknowledged in leading texts. You'll see in the bibliography. I've quoted a number of texts. If you're interested in pursuing this sort of understanding of this area of law, I'd suggest that you read any of Michael Grusin's material. He's a New York attorney, and he takes a very complicated subject and tries to make it fairly understandable. In any event, that public policy gap can be narrowed, okay, if you can get your foreign counsel to say that nothing on the face of the agreement would appear to violate public policy. Or you can have foreign counsel say, for the purposes of the validity of choice of law provision only, I will say that if this agreement was governed by the laws of jurisdiction of whatever, that the agreement would be binding and enforceable. So that narrows your, because you can say then, well, you know, if that's not, I'm not saying that's a panacea solution, but it helps for you to get some comfort here on the problem where counsel says, well, yeah, our courts will apply foreign law, for Ontario law to the contract, provided it doesn't, it's not, none of Ontario laws are void against public policy. In those circumstances, you have to discuss, okay, negotiate, and that's why you want independent counsel. Because if you're dealing with counsel acting for the foreign party, they're less sympathetic to, and your client doesn't understand what the problem is, really. So there are limitations in Ontario. As I said, it's validity of choice of law provisions are the foreign jurisdictions. Choice of law between the parties is acceptable as long as it's bona fide, legal, and not contrary to public policy. There are restrictions in Ontario, such as the PBSA, Section 5 says, and you get this where you're acting for U.S. attorneys who say, we'd like you to act on our behalf in registering the security agreement, and the security agreement says that the security interested and all the rights under the security agreement is governed by the laws of the state of New York. You say, well, our PPSA says that the validity and perfection of security interests is governed by the situs of the goods, so Ontario law is going to apply to your validity and perfection of the security interest. Those are limitations on choice of law provisions. Competition Act is another limitation. Employment Standards Act is another limitation. Parties may have some document that it purports to create some employment arrangement that is going to be governed by the laws of Tennessee, and you're going to say, well, you know, you can't contract out of Section 3 of the Employment Standards Act, but aside from that, you know, the terms of the agreement seem reasonable. I'll just want to skip along because we're really running late, and in the next 5 minutes I'll deal with two other items that I think you want to be aware of. I'm going to ignore, for the purpose of our discussion, issues of corporate status, what we call more banal or mundane types of opinion matters. I've dealt with those both for common law and civil law jurisdictions in the paper. That is the opinion on corporate status. It's pretty straightforward, you know, duly incorporated, validly existing, etc. Sometimes you get into problems with in good standing in all jurisdictions in which it conducts business. But that's not, those are usually things that can be worked out fairly easily. Corporate power and authorization is another item that's typically dealt with in a very similar fashion as domestic transaction. The corporate power is going to be governed by the laws where the party is incorporated. And that's, in my experience, that is not the hot issues or the contested issues in legal opinion papers, legal opinion requirements. You send a legal opinion, you rarely get somebody saying, well, they don't have the corporate, we can't give you an opinion on their corporate power. You might ask Richard Devenney this afternoon how they deal with that in Eastern, and how he deals with that in Eastern Europe. Execution and delivery, again, would seem very straightforward matter. It's a little bit more complicated because Ontario laws, conflict of laws rules, are not entirely clear about whose rules govern how a document ought to be executed. In Ontario, we know it's either the proper law of the contract or the place where contracting occurs. Proper law of the contract is the governing law, so as long as you're satisfied that it's been executed in a proper fashion in Ontario, then you can get satisfaction that it's been executed properly. If the laws of the foreign jurisdiction apply, then you should be okay on execution and delivery. Rarely a problem, but you should be aware that it's not clear in Ontario. Our conflicts of laws rules in Ontario are not clear as to whose laws govern the rules with respect to how a document should be executed. Okay. Opinion on forum selection clauses. I've dealt with that in some detail. There's, in my paper, there's very important, basic point to remember, opinion on forum selection, contractual submission clauses, is that you probably won't be able to get an unqualified opinion. Even though Ontario law says the courts, notwithstanding parties' agreement to submit a claim to a foreign jurisdiction, Ontario courts have said that they reserve the inherent right to hear a case. I mean, they've also said in a recent case of Ash and Lloyd's, which deals with, is a very interesting case, deals with letters of credit and allegations of fraud against Lloyd's Insurance. They've said that these clauses ought to be respected, but in the same breath they'll say, but that doesn't mean that we are bound. This is an Ontario Court of Appeal decision, that the courts in Ontario are bound to accept a party's choice of jurisdiction. We'll decide when we hear the case whether we ought to not hear it or not. But their tendency is to grant a stay on the application of the other part, the defendant, where the Ontario plaintiff has agreed to submit to a foreign jurisdiction. The converse is also true. Just because you've chosen Ontario as a place to hear a case doesn't mean that Ontario court will agree to hear a case. It may exercise its discretion in the case of illicit alibi pendants to not hear a case or to stay proceedings if proceedings are already commenced in another jurisdiction. In our example, we obviously want to bring suit in Ontario, and so, as I said to you, there's two aspects of this. First and foremost, it's less expensive, it's more certain, costs are less. In the U.S., in the absence of a clause to the contrary, each party is responsible for its own costs. There's no general rule that says loser pays a portion of the other party's costs. Well, that's a consideration that I think your client wants to take into account if your client is the more likely party to be suing, because if he's more likely to be suing for debt than frivolous defenses, easily made, no risk, delay, even no risk of incurring further costs because of litigation. So your client has a number of reasons of why he wants to know that he can sue in Ontario. So you want to know, if you have that kind of provision, how the courts in the foreign jurisdiction have treated that provision. They'll likely say, we can't give you an unqualified opinion, but we can tell you that generally speaking they are prepared to, and that's useful information to know. Secondly, and most importantly, is that you'll want an opinion from foreign counsel that the agreement to submit to the foreign jurisdiction, the agreement to submit to the courts of the foreign jurisdiction is sufficient to create in personam jurisdiction over the defendant for the purposes of enforcement of foreign judgment proceedings in the foreign jurisdiction. So what that means is that having agreed that Ontario courts will hear the case, that an Ontario judgment will not be refused to be enforced on the basis that the Ontario court lacked jurisdiction. There may be other reasons for refusal to enforce fraud on the manifest error on the face of a default judgment. But generally speaking, you'll want to know from a starting point that having chosen this, that it's, and this is why you want the clause in there. It's not just because you think that it's going to be enforceable, because it probably won't be, but it may be very persuasive. But the important thing is that you've created some jurisdiction which will allow you to bring an action in Ontario and then have your judgment enforced, particularly in the U.S. That's a requirement under the Uniform Foreign Money Judgments Recognition Act. 22 states have signed on. Most of the major states have signed on. And, if you have that clause, it's helpful to you in enforcing your judgment in the foreign jurisdiction. I have dealt with, in my paper, enforcement of foreign judgments. And I've given you the Ontario position on page 24 of the paper. You'll see the references to the applicable cases dealing with fraud, natural justice, etc. And then finally, as I said in the enforcement of foreign judgments provision, that really everything now is focused on the Morgard and de Savoy case. You probably have all heard about it. I'm sure Robert Cosman's going to talk about the Morgard case this afternoon. It's dealt with in some detail in my paper, and you'll see in the conclusion I've mentioned that there is no convention on international enforcement of foreign judgments, and that's one of the problems. That's one of the big uncertainties, in my view, in conducting international business. You don't know where you have to sue, if you get a judgment, is it enforced, etc. If we had a treaty convention on enforcement of foreign judgments. Things would be a lot more straightforward. The business law section of the American Bar Association tried to get this on the agenda at the Hague Diplomatic Conference this year in May. The Hague Conference was more interested in other public international rules right now, so it was set down for 3 years to be brought forward in 3 years. So we've got at least 3 years of this uncertainty and this where we can't look to an international treaty on enforcement of judgments. If there are any questions, I'm sorry. Greg should have been saying 1 minute or something. 2 minutes, Stephen.
Self-regulation.
Self-regulation. Are there any questions? If not, we'll see you at...
Can I just make one point before we close, Stephen? In terms of the interplay between competition laws and intellectual property rights, I refer to the block exemptions in the European Commission in respect of patenting in the paper. There are some other block exemptions that I'll refer to right now. You might want to take a note of these in respect of research and development. If you look at Commission Regulation number 418 of 85, if you look for know-how licensing, Commission Regulation number 556 of 89, and if you look for, in respect of franchise agreements involving know-how and trademarks, Commission Regulation number 4087 of 88. Those are valuable not only for practical consideration, but also from the point of view of looking at how the European Commission has resolved the interplay between intellectual property rights and competition laws.
Thank you very much. All right, so enjoy lunch, and we'll see you at 1:15.